Good afternoon. I was asked to discuss what's going on with Zoe Perez, also known as Furry Potato, in her lawsuit against Grunfeld, the security guard who shot her in the leg. I think it was February of 2019. She's included in her suit the synagogue that employed him. I guess technically the synagogue and the school that employed the company that employed him. They also sued the company that employed Grunfeld, which was Stealth Protective Services. The idea is that Zoe Perez, this case is about over because the school and the synagogue have both demurred out. They are no longer defendants. And Zoe has to pay their costs, which would include attorney's fees and filing fees and things like that. As of this point, Stealth Protective Services, the employer for Grunfeld, has demurred out of everything except for negligence, vicarious liability for the negligence of Grunfeld. And while that sounds like they've gotten, there's like 5 or 6 causes of action. So while it sounds like they are doing really well, negligence is the big bugbear that they're facing. And the reason why is because the negligence includes all of the medical bills that Zoe Perez incurred, all of the future medical bills that she may incur, any emotional distress that she may have incurred, which can include things like humiliation. And she was arrested for being shot. All of these things can go into it. I don't know if she has an expert or if she's going to get an expert to sit down with her and like a psychologist or psychiatrist and establish the future costs for psychological treatment for her, but that can be pretty substantial. Then you add into it potential punitive damages. I believe that she sued for exemplary damages, but I'm not entirely sure. I haven't gone back and read any of the complaints, but I would bet that she has sued for exemplary damages. And those can be pretty substantial. Now, whether or not she can reach the SPS, the employer for Grunfeld, with the punitive damages is a different story. Whether she could reach them with any of the damages is a different story. But they've got big pockets, and keeping them in this lawsuit is the big deal. That's the big deal. Because, reality is that suing a security guard isn't going to get you rich, because if she got a $10 million judgment against a security guard, he could waltz into bankruptcy court the next day, file bankruptcy, and it would all go away, essentially. So, assuming he doesn't have any real assets, and he's a security guard, so I'm going to assume he doesn't have any real assets. So what transpired? Well, this is I guess a minute order. This is the judge has confirmed the tentative ruling. The way it happens with the demur is, at least in California, the day before the demur would be heard, the judge will issue a tentative ruling. And maybe it's 2 days before, maybe it's, I don't know how long it's going to be before, maybe 2 weeks before. Who knows? This is all going to vary by county. But at a point before the demurrer is to be heard, the judge will issue a tentative ruling. And what inevitably happens is one of the parties will disagree with the tentative ruling and will notify the court and notify the opposing party that they intend to request oral arguments. So the next day, the attorneys will appear and will argue basically the same thing that they had put in all of their briefings to the judge, and the judge will 99% of the time just affirm the tentative ruling. And that's exactly what happened in this case. But it's interesting to see what has transpired. So initially, Zoe Perez filed a complaint against the defendants alleging 5 causes of action: assault and battery, false imprisonment, negligence, violations of the Ralph Civil Rights Act, and violations of the Bain Civil Rights Act. She then did a first amended complaint against them. You can amend it as a matter of right once, I believe, before they filed an answer, but I'm not entirely sure if she did it as a matter of right. Anyway, so she amended her complaint once, and it's the same allegations. She probably just corrected a few factual mistakes or added a few things. And I'm not, maybe it was, maybe the First Amendment complaint is where she put in the actual, she substituted in the actual new defendants for the does, like SPS for doe 1 and the synagogue for doe 2 and the school for doe 3, whatever. So then everybody filed demurrers to the First Amendment complaint. And the court sustained the demurrers for the school and the congregation to all of the causes of action. And they sustained Grunfeld's demurrers for some of the causes of action. That was to the first amended complaint. So Zoe went back to the drawing board with her attorneys, and they prepared a second amended complaint because the court had sustained the demurrers with leave to amend. So, I mean, that's what you do. You go back to the drawing board and you amend the complaint. You make sure that you allege sufficient facts that if those facts were true, then you could win on your cause of action. That's what these demurrers are. A demurrer is essentially saying to the court, hey, look, even if everything that they allege in their complaint was true, just assuming everything in their complaint is true, even so, they would lose as a matter of law. They don't allege enough. They don't actually allege all of the particular elements of their cause of action. And so that's Zoe failed on the first amended complaint because she didn't allege sufficient facts that as a matter of law would allow her to prevail even if she proved every fact to be true. So she amended it. And when she amended it, she added in an UNRRA Act violation. So now there's 6 causes of action. And again, everybody demurred. And so with regards to the assault and battery, the court sustained without leave to amend for the employer, the school, and the congregation. First, which was assault and battery. Second, which was false imprisonment. Third, which was negligence. Fourth, which was the Ralph Act. Fifth, which was the Bain Act. And sixth was the UNRRA Act. And then as far as Grunfeld was concerned, they sustained without leave to amend the demurrer of Grunfeld to the second, which was false imprisonment, and sixth, which was the UNRRA Act cause of action. So as far as everybody is concerned, 2 and 6 are gone. False imprisonment is gone, and the UNRRA Act is gone. Or was it the Ralph Act? Which one was the 6th one? The UNRRA Act. Yeah, okay. Yeah, so I was right. So now, she filed a motion for reconsideration. The court denied the motion for reconsideration with respect to the school and congregation defendants as well as SPS. But the court has the power always to change its mind, to change its orders, to change its rulings. And the court said, you know what? As far as negligence is concerned, we think you screwed up, and we think you should have been able to allege sufficient facts that as a matter of law, if everything that you allege is true, then SPS would be on the hook. You should have been able to do that. So as far as that third cause of action, as far as negligence against SPS, you can go ahead and amend your complaint. And so they did that. And there's the third amended complaint. So the third amended complaint is now, strangely enough, assault and battery, negligence. They've added in negligent hiring, retention, and supervision. That's weird. Then they still have Ralph and the Bain Act. So the court said that you can amend your second amended complaint for the negligence. But they went ahead and added negligent hiring, retention, and supervision, which are elements of the negligence as it would apply to SPS. Because obviously it's not SPS's actions. SPS didn't pull the trigger on the assault and battery, etc. But they hired a guy who did that, and they trained him, and they retained him, and they supervised him when they shouldn't have, or at least that's what her allegations are. So again, we're not looking at the proof. We're just looking at the allegations at this point. So SPS filed a demurrer to the second and third, to the negligence and the negligent hiring, retention, and supervision. And what the court did is the court denied the demurrer as far as the second cause of action is concerned, as far as negligence is concerned. But they don't even address denying the third cause of action, sustaining the demurrer. They sustained the demurrer on the second cause of action. They didn't reach sustaining the demurrer on the third cause of action because they said you didn't have authority. The court didn't grant you the authority for making an allegation for the third cause of action. So the court didn't grant them permission to raise it. And so the court strikes it because it was improper. They shouldn't have raised it. And so, well, I guess he did sustain without leave to amend the third cause of action. I thought they just struck it, but okay. Another thing that the court notes is that the school and congregation were already basically out of the lawsuit, even though they're still named as defendants in the third cause of action. So plaintiff, that would be Zoe, has to file a request to dismiss, which dismisses them, the school and the congregations, from the action. And then the court says that counsel for the moving party will file notice of the trial date. Normally it's the prevailing party who files it unless the court says otherwise. I guess since this one was split, the demurrer was granted or sustained as far as the third cause of action is concerned and overruled as far as the second cause of action was concerned. The court said, well, we'll just have the moving party prepare the notice. So that's what all of this minute order was. And so strangely enough, I guess Zoe's attorneys didn't read the order clearly enough because they prepared a notice of ruling where they submit the court's minute order. I'm sure they really appreciated typing this all up. But then correctly, the attorneys for SPS filed their notice of ruling. So that corrected that all up. Now, as far as costs are concerned, the court did award defendants costs in the above captioned action. I don't know what's going on with their font in this one. You can see like they have weird font issues going on. U's are weird, Y's are weird, V's are weird, P's are weird, the J's are weird. I don't know what's going on. That's just all weird. But I guess it's still legible. Above captioned action. Judgment. It's just weird. Anyway, so what costs is Zoe likely to have to pay? Well, to file 2 demurrers, I would guess there's somewhere around 25-ish hours, oral arguments on both, I'm assuming. So maybe 30 hours, roughly. 30 hours. It depends on how much it depends on how much Manning Class, Elrod, and Ramirez are charging. I'm going to guess, being down in LA, that they're charging somewhere around $500 an hour, roughly, which would make it about $15,000. Now that doesn't mean that that's what she'll pay, because attorney's fees and costs, the court has the power. Basically, they have to submit their attorney's fees and costs to the court. They can ask. They'll basically have to say that these are reasonable, and they'll have to show what other people are kind of charging in the area and what courts have found to be reasonable as far as attorney's fees and costs are concerned. The attorneys for Zoe can also submit, a declaration saying that, this isn't reasonable. These are more in line with what people are charging for this kind of experience, etc. And so let's see. Let's look at, I just want to see something real quick. So for example, any time that Carpenter would spend on something with a much lower state bar number is going to be reasonably charged at a higher rate than someone with a higher state bar number. So Carlos Hernandez is probably the attorney who wrote all this stuff, may have even argued it. Let's see who was present to argue it. Let's see who was present. Yeah, so Carlos Hernandez argued it. I mean, this is pretty standard. This is a lot of what I do. The big name is the name by, it's his case, but Carlos is going to do all the work on it. So Carlos's time is going to be worth a lot less because he probably has 2 to 3 years of experience at this point, and so, his time is going to be worth less than Carpenter's time. Although for these guys, it was hold on a second. It was these guys. Okay, so Joshua Bodaber, he's probably got 2 or 3 years of experience. His time is going to be charged less. He probably did most of the work. Alberto probably did the second most amount of work, and then Egan probably did the least amount of work, but is ultimately like the attorney of record for the case. Anyway, so could Zoe pay upwards of $20,000 in attorney's fees and costs? Possibly, but the likelihood of that is pretty low. Bray Telephonic was Olson, actually. Interesting. And who's Olson? Yeah, Olson probably has about 10 years of experience. So, yeah, there you go. So, like I said, it's not dead for Zoe. She still has SPS, which is going to have deep pockets on the hook for the negligence portion. So she could still come out with some money. She could still come out with a settlement. Trial. This is going to be expensive. I mean, I up here in the Sacramento area, you're looking at like 20 to 50 grand for, after you get through all discovery and everything like that. Down in LA, where prices are even higher, where attorney's fees are even higher, you're probably looking at, 40 to 70 grand, I would guess. So this could get quite expensive, but if Zoe's just on contingency, then it's all going to be on Mr. Carpenter to fund everything, and won't be that bad for her. Yeah. Anyway, that's about it. Thanks for watching. Have a great day.